the whole concept of nomination. If there is an asset in your name, or if you are making someone a nominee, what does that really mean? And how does that tie in with things like legal heir or a will?
There is a very, very large segment which is there that actually has no idea of what is going on, where patriarch is the one who's running the business, running the show. The woman is just signing papers and not being aware of what's going on, which in case something happens to the patriarch, then they are left flustered, not knowing what to do.
Women are at the forefront in essentially starting this exercise of really succession planning for the family. Very often, men essentially take it too easy and they do not believe that it is something which is important for them to do. More so often, especially where they are the working member, do not find it important enough to really spend the time.
If a man passes away, if the man was a Hindu, then his legal heir are his mother, his wife, and his kids in equal proportions. That is as per the Hindu law. However, when we talk about a nominee, if the same man owned a flat, he can have his wife as a nominee. That wife might is not the only legal heir.
Very often, you've seen situations where an apartment, or for that matter, when you're having a demat account or you have a bank account, you will put in the name of the nominee, whoever really comes first to your mind, without there really being any real thinking as to whether this person is supposed to really hold the asset after the demise. Now, what is important and what we generally would tell families is that try and have the nominee to that particular asset and the heir under your will as the same person, in order to really avoid family disputes.
Hmm.
Now, though the law is extremely clear that the nominee is not the owner, and it is, the person in this under the succession laws, or for that matter, whoever is, positioned in the will, is the owner of the asset. You just don't want to get into this particular, doldrums as to whether or not the owner of the asset actually intended for the asset to go to the nominee,
Right.
or not have a will and it goes under the succession laws.
Ancestral property, everybody is getting an equal right in the property. Earlier, it wasn't there. A woman was only getting a right in her father's self acquired assets and not the ancestral assets. So it becomes very important now to have a will and to mention the assets which are owned by or owned or acquired by an individual, and mention who's going to inherit these assets, in what ratio. You can mention what the ancestral asset is, but then it is going to go equally between all the kids of the family.
Every woman should really create her own will. To the extent that the property values are extremely large, there are more sophisticated tools of planning which a woman can really undertake and undergo. And that is something which I would urge women to understand their assets, not only their self acquired, but also their assets which they are inheriting, either from their parents, from their in laws, from their husband, before really, diving into which mode of succession you really want to go into.